Patrick Montgomery, attorney at law. Ms. Rodriguez, would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you, ma'am. Ms. Rodriguez, before we proceed, I need to remind you and make sure you know and understand that you have certain constitutional rights and protections. First one, you have the right to remain silent. That means you do not have to say any kind of statement, nada. You don't have to answer questions. You don't have to submit paperwork that has or contains a confession or admission to wrongdoing. Do you understand you have that right to remain silent?
Yes.
You have the right to a jury trial. That means that you and your attorney and the state could select 6 people from a jury panel. They would be randomly selected. They would hear the testimony and evidence and see whatever documents, whatever in your case, and decide whether you're guilty or not. That's the right to a jury trial. Do you understand that?
Yes.
You have the right to confront witnesses, meaning you have the right to face anyone who testifies. That means that you and your attorney could cross-examine, question, or challenge any person who would testify. That's the right of confrontation. You understand that?
Yes, sir.
You have the right to an appeal. When all is said and done and the dust settles, you and your attorney would have the right to demand that a higher court review the official record in this hearing and decide whatever challenge you wanted to make. To do that, you'd have to use the right paperwork and be careful of the time limits. That is the right to appeal. Is that clear?
Yes.
You also have the right to demand that this proceeding be held in the open public courtroom. Because of the COVID pandemic, we're not doing that. We're doing these proceedings by video conference. This video conference, by the way, is being streamed on YouTube. It is live to the public, but it is not in the open public courtroom that is required. These different rights that I have just mentioned to you, if you persist in a plea, you give up those rights. Did you know and understand that?
Yes.
All right. Now, I'm going to show you some documents, and all of them will start off with what I call identifying information at the top. It says the case number 648013. Then it says the state of Texas versus Maria Elena Rodriguez in County Court at Law number 5, Bexar County, Texas. That's the identifying information. It will be repeated on almost every document we're going to look at.
Okay.
Below that identifying information is a title for the different documents. This one is the state's consent to video conference. I mentioned a moment ago that the state has the right to demand a public hearing too, but they are in agreement so that we can do this proceeding as we are doing on video conference. You notice this is signed by Caitlin C. Morgan on behalf of the DA's office. Did you see and understand that?
Yes.
Now, the second document, again, has the identifying information. Then it is titled Discovery Acknowledgement. What that means is this. There is a particular law, and you see it right there, the very first line, Article 39.14 of the Code of Criminal Procedure. That particular law, the state of Texas requires the prosecutors, the state's attorneys, to submit, acknowledge, or allow you to see all the evidence, whether they're receipts, books, documents, videos, whatever. They have to show it to you and share it with you. This is signed by your attorney and the state's attorney. They are saying that that law has been obeyed. Did you see and understand that?
Yes.
All right. The next one is your document where you agree to the video conference. I talked about that a while ago. You just saw the one for the state. This is yours. Did you understand what you signed there?
Yes.
And it is signed by you.
Yes.
All right. Now, the next document, again, the video rather the identifying information, then the title here is Defendant's Waiver of Constitutional Rights and Court's Admonitions. It starts off with 3 separate sentences. You were originally charged with DWI with BAC 0.15 or higher. That means particularly that you were first charged with extreme intoxication. They're saying you were very intoxicated when you were stopped. The third sentence says, what does it say? Read it.
In this case, I hereby enter a plea of nolo contender to the following allegations. DWI first.
All right. So what that means, first off, is that your attorney has made a deal that reduces this charge from a Class A, basically punishment wise, to a Class B, DWI first, by way of punishment. It's a little bit different, but it changes it significantly as far as the punishment. Now, the rest of this document is divided into 15 numbered parts or divisions.
Mhm.
The very first one talks about what the punishment is for you, the range of punishment for the charge you've got. The very first box on the stack of vertically stacked boxes is marked, and it says DWI first. What does that say is for punishment, ma'am?
DWI first, $0 to $2,000 fine and 72 hours to 180 days in jail.
That is what the punishment can be, anywhere in that range. Now, Mr. Montgomery, did you and Ms. Rodriguez carefully review this entire document?
We did, Judge. We scheduled a Zoom meeting independent of this meeting, and we did the same share screen that you're doing right now, and we went over all this paperwork together.
All right. Now, among the things in there, it tells you, Ms. Rodriguez, that the deal you've made with the state, I have to say yes or no. It is not binding on me. I can give you any punishment in the range that we talked about, even if it's heavier than what you agreed to. Now, if I reject your deal, I would say, no, I'm not taking this deal. We're not going to do that. Or if I give you a punishment that's heavier than what you agreed to, but within the proper range, then you would have the right to start all over again. And nothing that you said or anything that you signed would be used against you. Did you understand that?
Yes.
All right, these 15 paragraphs are sections or divisions. They're numbered 1 through 15. Do you have any question regarding any of them?
Only the first one, the one that I had read, I think Mr. Montgomery said it was wrong.
Okay.
The
And
range of
perhaps-
punishment, or excuse me, the charge at the beginning, sir, is what she refers to. If you'll scroll up just a tiny bit, Your Honor.
Okay, the DWI,
It was originally a DWI with blood alcohol
right,
of 0.15 or higher.
okay.
And so
If
that's
you
not
look-
correct with the charge being lowered. So the correct box is checked rather under number 1.
All right,
Ms. Rodriguez
Just-
noticed that discrepancy and I explained to her it's a result of the charge being lowered.
okay. Just so you know, make it very clear. The very first box talks about the range of punishment. In this particular case, the range of punishment for you is be DWI first. Now, you were originally charged, as I mentioned a while ago, with extreme intoxication, 0.15 or higher.
Yes.
But that's not going to be what you're going to be punished for, because you're not going to plead to 0.15 or higher or extreme intoxication. You're going to plead to DWI first, which is lower. Is that clear?
Okay. Yes.
The second box, by the way, tells you what would be $0 to $4,000 in jail from 0 days to 1 year. But that's not applicable because your attorney has gotten you a deal for a lesser charge.
Yes, sir.
Okay.
Okay.
Now, if you'll scroll, Mr. Lozano. This document here, this is where I make a certification to you concerning that you do not have a right of appeal. There's a stack of boxes vertically stacked, and each one has a different declaration concerning the right of appeal. The fifth box, 1, 2, 3, 4, 5, says, I'll have that marked for the papers for the record. It says this is a plea bargain case, and the defendant has no right of appeal. If you make a plea bargain, you lose the right to appeal. You don't really lose it, you give it up. Is that understood?
Yes.
All right. Now you're going to have the application for judge-ordered community supervision probation. Now, this is going to be deferred or not?
Your Honor, it's straight probation. I would
Okay,
ask you for deferred, but it would bust the deal.
all right,
Ms. Morgan gave me a smile on that one.
all righty. Now, just so you know and understand very clearly, Ms. Rodriguez, probation is a written, legal, binding agreement between you and this court. In the punishment, there will be a jail sentence, but that will be suspended so long as you live up to 100% of the conditions of supervision. You'll have a bunch of conditions. The one suspended is the jail part. If you violate those conditions, if you refuse to do them or you fail to do them, either way, then the state can ask me to give you official notice and bring you in for a hearing. And if the evidence supports it, I can then send you to jail for the amount of time that is in this order. Is that clear?
Yes.
All right. Did you review that application with Mr. Montgomery?
Yes, sir.
Did you know and understand what you're telling me under oath by signing that application?
Yes.
All right. Any questions about this?
No, Your Honor.
All right. Now you're seeing the personal data sheet. That one doesn't have the identifying information because this whole thing identifies you.
Okay.
You got your name, address, phone number, everything in there.
Yeah.
Then you're employed by Joanne
Join, no.
Null. Okay.
Yes.
How long have you worked for her?
3 years.
Okay. You work part-time?
Yes.
How many hours a week?
30.
So that's 450 a week.
Yes.
All righty. Then you've got your 3 references that can always find you.
Yes, sir.
Okay. Then there you go. You are divorced.
Yes.
You have 1 dependent.
Yes. She's my granddaughter. She's 23, but she lives with me.
Okay. Legally, I cannot consider that a dependent because she's 23, unless she's got medical issues.
No. She
Okay.
just never married.
You have a pickup,
Yes.
2017. Nice. Okay. We're gonna now reload because we're gonna put in the actual plea agreement. It'll be a moment. There it is.
Mhm.
Ms. Rodriguez, the first 2 boxes will be marked on the record. The first one talks about, guess what? The right of silence.
Okay.
It says that you know and understand that that's what's involved here, that you're giving that up. Then there's a second box. It says that you are a U.S. citizen. You told me you were born here.
Yes.
So then there's 5. There's a section called defendant's acknowledgements. Mr. Mr. Montgomery, you and your client reviewed this section with the 5 check marks on the boxes.
Yes, sir, we discussed it.
All right. Ms. Rodriguez, do you have any questions about those? They're all about your rights and protections.
No, I don't have any questions.
And then we have a section on DWI, the specifics of what we're doing here. Ms. Morgan, you have a motion.
Yes, Your Honor, the state moves to waive and abandon the extreme intoxication enhancement and proceed on a DWI first.
All right. Defense, any objection?
None, Your Honor.
All right. Then that being the case, the last box in that section will be marked because the court is granting that motion. That means officially Ms. Rodriguez, that you're no longer charged with extreme intoxication. In fact, now you're charged with DWI first.
Okay.
To that charge of DWI first, how do you plead, ma'am?
Guilty.
All right, you want to look at the papers and look at it again?
Mm-hmm.
What does it say, ma'am? You're pleading what?
No,
Nolo contendere, also
Contender.
known as no contest. Okay,
okay,
that is correct. That is my understanding.
yes,
Now, before anything else, I am ordering you to appear in the offices of County Court Law number 5 so that your thumbprint can be placed on the documents as required by law. Is that clear?
yes,
Now, based on your plea of no contest, I find you guilty. You're sentenced to 180 days, Bexar County Jail, probated, suspended for a term of 1 year. You are fined $400, of which the $400 will be probated or waived if you live up to 100% of the conditions of supervision. You will perform 48 hours of community service. By the way, does your granddaughter provide any help to you?
she's not working right now.
Okay. As part of the sentence, you will also participate in, enroll, and complete the DWI education program, the DWI Victim Impact Panel. You will submit to a TAP evaluation and follow the recommendations. You'll have 6 months of ignition interlock monitor on your truck. During those 6 months, you're not to drive any other vehicle other than your own equipped with that ignition interlock. Is that understood?
Yes,
And during the entire period of probation, you're not to have any alcohol at all. Is that clear?
yes,
All right. Your supervisory fee will be $29 a month. Ms. Rodriguez, do you have any questions about this proceeding or the documents?
no, sir.
Mr. Montgomery, any questions concerning this proceeding?
None, Your Honor.
And Ms. Morgan, any questions?
Nothing from the state, Your Honor.
All right. Ms. Luna and Ms. Rodriguez, you two ladies will meet as soon as we're through here so that we can, you can get ready for the probation. Just to remind you, the conditions of probation are going to be read to you. You will sign them and they will put a copy in your hands. So you'll always know what your conditions are and you keep that handy.
Okay,
All right.
okay, thank
You
you.
stay out of trouble. Good luck to you.
I will. Thank you.
Stay safe.